As we discussed in Episode 1, the Fourth Amendment is a broad declaration of our rights to be secure in our persons and property. But like all our rights, it is only good so long as the courts interpret and apply the right consistent with the framers' understanding. Early on, that's what happened. In the first major Fourth Amendment case, the U.S. Supreme Court rejected the government's claim that it could open letters and packages traveling through the mail, holding that the constitutional guarantee of the right of the people to be secure in their papers against unreasonable search and seizures extends to their papers, thus closed against inspection, wherever they may be. In another early case, the Supreme Court rejected the government's attempt to subpoena a person's private papers for use in a forfeiture proceeding and declared that constitutional provisions for the security of person and property should be liberally construed. A close and literal construction deprives them of half of their efficacy and leads to a gradual depreciation of the right, as if it had consisted more in sound than in substance. It is the duty of courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments therein. But despite the court's admonition in Boyd, its diligence in protecting Americans' property rights began to wane during Prohibition. To give federal agents broader authority to search for illegal alcohol production, the court ignored its previous commitment to a liberal construction by restricting what types of property the Fourth Amendment protected. In 1924, the Supreme Court held in Hester v. United States, the Fourth Amendment did not protect private land, since the amendment only protects persons, houses, papers, and effects. A few years later, the court held that agents could wiretap a phone line without first getting a warrant, because the line didn't belong to the defendant, so it was not his effect. The court's narrow reading of the text, often called strict constructionism, was a surprise to many. John Adams had said judges should not read constitutional guarantees narrowly, but instead should apply them as the framers themselves would have done if they had foreseen the things that happened. Early Supreme Court Justices John Marshall and Joseph Story had each rejected narrow interpretive approaches. The court's very narrow reading of the amendment completely upended the intent of the founders. Several decades after Prohibition, the Supreme Court shifted its approach in Katz v. United States. Instead of sticking to a strict literal reading of the Fourth Amendment, the court said the Fourth Amendment protects people, not places. In doing so, it moved away from the idea that only specific items listed in the amendment were protected. The justices created a new test focused on whether the government violated a person's actual expectation of privacy and whether that expectation is one society would consider reasonable. Despite the rich historical record, the court took a serious wrong turn. It moved away from the Fourth Amendment's original grounding in property rights and tied it instead to the nebulous idea of privacy. The final nail in the coffin of protection against warrantless searches came in 1984. In Oliver v. U.S., SCOTUS ruled government agents did not commit an illegal search despite ignoring numerous no trespassing signs, because landowners have no legitimate expectation that open fields will remain free from warrantless intrusion by government officers. Government agents nationwide now routinely use the Oliver ruling as tacit approval by the courts to conduct warrantless searches. This has left more than 96% of the privately owned property with no Fourth Amendment protections nationwide. In Idaho, only 2.9% of private land is eligible for Fourth Amendment protections.